Good morning, Your Honor. May it please the Court. Dan Polsenberg for the Clark County School District Defendants. This certainly is a tragic case, and our hearts go out to the Lamberths. But all of these cases are tragic. This Court pointed that out in Patel. Justice Rehnquist pointed that out in Descheny. But just because there is a terrible situation doesn't mean that there is a constitutional remedy as opposed to a state law remedy. And let's look at, we're drilling down on the exception.
So what is the status of the Clark County District Court?
The trial was just continued, and the trial is going to take place in August.
Okay, so that case is proceeding forward.
It is.
Okay.
Very much so.
Okay.
We're drilling down on the exception, but let's remember the general rule to which we have this exception. That is that a substantive due process claim can be brought against the government for the government's actions. Now, there are a few exceptions to that, and we're dealing with the exception where the state actually creates the danger.
Well, that's not what our cases are limited to. The state doesn't have to itself create the danger. It has to, there can be an existing danger that the state does something affirmative.
Judge Wofford, I agree.
Hang on, that makes the situation worse, right?
Yes.
Okay, so here I thought the plaintiff's best theory was this, that beyond just failing to intervene when really the state should have to do something about this or to at least alert the parents, the reason the state made it affirmatively worse is because I think there was a meeting between Haley and one of the school deans at which the dean made Haley aware that, yes, the school knew about this harassment that was going on. And then, in combination with the training she had received, which suggested that if harassment were serious, the school would do something. When the school did nothing after that, that's when Haley said, well, I guess there's no way out.
Well, that's a new theory. That wasn't argued in the district court, and I'm not sure it was in the opening brief. That seems to be more, and that was Judge Tallman's question to plaintiffs, is the argument that the school district caused her despondency. And I don't think that's what this case has been about. And factually, what they've alleged, now I'm trying to carve out what we know from discovery and what's in the complaint. They allege that there was a report of bullying, that one dean met with Haley and one dean met with JJ. They talked to them, and it's clear from both the exhibits to the opposition to the motion summary judgment and the opposition to the motion amend that there was no problem between those students ever again after that. And the school district was not aware of any other bullying having to do with Haley until after her death.
I thought the online report that was submitted, which went to the dean, involved not JJ, but the other student. No,
that was JJ. CG did an online report involving Haley's encounter, and she put it in the plural, but there's nothing to say that there actually was, besides that and subsequent reports, that there was more than one encounter in PE class.
Well, I'm not sure it makes a difference which student it was. Haley felt victimized by both of the students who were harassing her.
But the school district did not know about CH at all.
Okay, well, again, it doesn't seem to me to matter.
I think it does matter. Judge Watford, let me explain why I think it matters. Because if their theory is that we created some kind of environment where Haley had an expectation that something more would be done, we would have to know that there was something in the first place.
Right, but so no one's disputing that one of these deans did learn about at least one of the students harassing her, right?
Sure, there's no dispute that we all knew about her encounter with JJ. One dean met with Haley, one dean met with JJ, investigated. Now, they dispute whether that's an investigation, but they were both interviewed about what happened, and nothing ever happened between those two students after that. So there was action taken. I would contend, based on the record that we have in front of this court, that there was adequate action taken. But I also disagree with, and I realize that you're saying that that's their best argument, but I don't think that action and the failure to go forward constitutes something that would fall under the state-created danger exception. and that's what we call it. And I understand it doesn't have to depend on us creating the danger, but we do have to at least do three things under the state-created danger exception. We have to take affirmative action. That action has to result in harm that is greater than the status quo, and we have to do that with deliberate indifference. Now, a lot of the opinions put those as two factors. I think the dissent from the rehearing and bank in Kennedy puts it as three factors. And certainly it's important that we look at the second one either as part of the first factor or by itself, because I don't think we meet any of those factors here. The failure to go further, the failure to intervene further, the failure to even to keep promises is not enough to be either affirmative action or affirmative action that causes greater danger.
Well, let me ask you this, and you'll dispute that these are the facts in this case, but let's say that the meeting with the dean resulted in a communication to Haley that said, listen, we're aware of all the harassment by all the students that you're enduring. We will take care of it. We have your back. This is not tolerable. We're gonna fix this. And she thereafter endured additional weeks of harassment and finally said, I guess nothing is going to be done. This is hopeless, and took her life as a result. In that scenario, are the three prongs as you've laid them out?
No, they're not, and for two different reasons. First of all, just making a promise is not enough. This court in Patel distinguished Kennedy by saying, okay, promises being made, although there were promises being made in Kennedy and we found a state-created danger, that wasn't the extent of the situation. In Patel, there were promises that wasn't enough to create a prima facie case of state-created danger, and in Kennedy, there was so much more than the promise. It wasn't just that the police promised to send patrol cars that night. It was that they had said to the family, we're not going to tell your neighbor that you reported the 13-year-old molester. And then they did tell the neighbors. I think
they just said, we'll let you know before we do that.
And then that was the second thing. They said, we'll let you know, and they didn't let them know.
Right.
So they created the danger. The police officers created the danger to the neighbors.
I guess I'm saying with a 13-year-old, and we all know how vulnerable 13-year-olds are to the kind of harassment that Haley was enduring, that it might be the case that the state makes things worse, right? The existing harassment is bad enough, and the state didn't create that. But you might well make that situation worse from the student standpoint if the school says, we're aware of this, and basically communicates through their acts that nonetheless we're not going to do anything about it. That could add an additional layer of despondency and hopelessness that might move a 13-year-old from just being very unhappy to actually taking their life.
Well, could. And they quoted one of my deans who said that this could have resulted in the suicide. And all she said when she said that was, well, could have. I don't think could have is enough. And that's why earlier when I was talking about your hypothetical, I said two reasons. The second reason is that the causation here, the foreseeability here of the suicide is so much more remote. Yes, we're dealing with 13-year-olds, and Your Honor, my clients deal with 13-year-olds every day. And you cannot say that this would be a foreseeable risk enough to be a known or obvious danger either for the third prong or enough to say that they were sending Haley into a dangerous situation just by letting her leave the dean's office. They keep saying we sent her back into the classroom, but there's no proof that the classroom was the place of the harm. It's not like the Kennedy case where the government or actors there actually caused the situation to be worse.
I think actually with the student JJ, it was in the classroom, if I remember.
Well, in the PE class, but that was never a problem again.
Right. Yeah, I'm not.
We know that to be the case.
I'm not sure you're right on that as a factual matter, but be that as it may. Can I ask you about the Title IX claim?
Certainly.
I know it was added late, but
quite late.
Yes. Okay. Well, maybe you can address why why isn't what they came forward enough to make out a viable Title IX claim?
Well, what Judge Gordon did in dealing with the motion to amend, remember, the plaintiffs were going only on a substantive due process claim, and after that was dismissed, 106 days after the deadline to move to amend, they added a Title IX claim, an ADA claim, an IDEA claim, a procedural due process claim, some equal protection claims, and there's another one I'm forgetting. And Judge Gordon said, well, no, remember, there are 4 reasons you can deny a motion to amend. It's in bad faith, it's dilatory, it's futile, and it causes prejudice. And the judge found, A, that the amendments were futile to save their substantive due process claim.
But I asked you about the Title IX claim.
Yes.
So maybe you could just zero in on that.
And B, that they were too late, that caused prejudice to us where fact discovery was closed.
Yeah, but they say that they did not learn of the facts that supported the Title IX claim until after, the original complaint had been filed, the motion to dismiss had been taken under submission.
And Judge Gordon flatly rejected that.
On what basis?
He said there's no newly discovered evidence. They don't come forward with what evidence is the basis of all their new claims, and they don't come forward with the reason why it's newly discovered. And he specifically found it would prejudice us to have to do discovery on those claims.
Didn't he also find intentional delay on the part of the plaintiffs that
He
they
did.
knew before the deadline?
He said it was all the new claims, he said it was a tactical, he may have said strategic decision to bring in these claims after the other claims had been dismissed, because they had said in their reply brief in the motion to amend that there was no reason to bring all these claims earlier. And so he took that as a admission that it was a purposeful and strategic decision. If the court has no other questions.
Judge Gould, do you have any questions?
No questions here.
Thank you, Your Honor.
Thank you, counsel. Counsel, I think you have 2 minutes and 43 seconds.